5, 4, 3, 2, 1, start. The present writ petition has been filed by the petitioner praying for quashing of the order dated 12th of November 2007 passed by the respondent number 3 rejecting the application for resignation made by the petitioner full stop. The petitioner is a serving officer of the military nursing service who was granted permanent commission in the army on 9th of August 2002 full stop. She was transferred by an order passed on 25th May 2007 to the 143rd General Hospital at Leh full stop. The petitioner is stated to have served in Command Hospital Chandi Mandir as well as in the military hospital Allahabad during the course of her service full stop. It is urged by Mr. Agarwal that in consonance with the traditions of the conservative Indian society in June 2007, the parents of the petitioner were considering marriage proposals for her full stop. A suitable match was identified by them full stop. The writ petition states that the proposed match was that of an IT professional who was permanently based at New Delhi full stop. It is further submitted that his parents were old and needing constant care and looking after full stop. The only precondition to the marriage which was laid down by the prospective in-laws was that would-be wife/daughter-in-law will not work and manage the house, devote herself to looking after home and in-laws full stop. In this background, the petitioner submitted her resignation from service on 25th of July 2007 to the respondents full stop. This application was scrutinized and recommended by not only the then principal matron under whom the petitioner was working but also by her commanding officer full stop. It was thereafter forwarded to the army headquarters through proper channel full stop. Stanza in the hopeful expectation that her resignation would be favorably considered, the petitioner advised her parents to finalize the marriage proposal full stop. However, by the impugned letter dated 13th of November 2007, the petitioner was informed by the army headquarters that her resignation was rejected by the Director General Medical Services for the reason that the grounds put forth were not extreme enough to warrant resignation full stop. The factual narration in the writ petition shows that on 23rd of January 2008, the petitioner was married to Shri Sanjeev Kapoor full stop. The petitioner submits that her husband and in-laws insisted that she should resign from her commission as the present service is not compatible with the service of her husband full stop. In view of the pressure from her husband and new in-laws as well as because of the prolonged separation resulting on account of her lay posting full stop. The petitioner has stated that she is mentally disturbed and is not able to focus on her work and professional duties which are of very sensitive nature and require full dedication and concentration full stop. In this background, the petitioner has filed the present writ petition seeking directions to the respondents to accept her resignation full stop. Mr. M.S. Sharma, learned counsel appearing for the petitioner, has vehemently contended that the action of the respondent is violative of the rights of the petitioner under Article 21 and 23 of the Constitution of India full stop. He has placed reliance on the pronouncement of the Apex Court to contend that fundamental rights of serving officers of the army have to be protected under all circumstances full stop. Learned counsel drawn our attention to the pronouncement of the division bench of this court and submitted that the action of the respondent in rejecting the resignation application of the petitioner was contrary to the well-settled principles laid down in this pronouncement to the effect that the continuance in service to meet exigencies thereof cannot be a ground for rejection of an application but can only serve as a ground for keeping the application in abeyance. Full stop. Stanza. Learned counsel for the petitioner has also placed strong reliance on the pronouncement of the Supreme Court in support of the contention that even a law providing that a person has to be compelled to serve for specific period would amount to forced labor, and such law would be void as offending Article 23. Full stop. It is submitted that the order of the respondent rejecting the petitioner's application for resignation is in the teeth of this well settled legal position and runs violative of Article 23 of the Constitution of India and cannot stand. Full stop. Our attention is also drawn to Article 16 of the Universal Declaration of Human Rights 1948, which has been signed and ratified by India, which recognizes right to life as a human right. Full stop. It is also provides that men and women of full age have the right to marry and found a family without any limitation, and further that they are entitled to equal rights as to marriage during its subsistence as well as dissolution. Full stop. The Universal Human Rights Declaration also recognizes that family is a natural and fundamental group unit of society which is entitled to protection by society and the state. Full stop. Our attention is also drawn to the Article 23 of the International Covenant on Civil and Political Rights 1966, which provides that the family is a natural and fundamental group unit of society which is entitled to protection by society and the state. Full stop. It is further stated that the right for men and women of marriageable age to marry and to found a family shall be recognized. Full stop. The state parties to the covenant undertook to take appropriate steps to ensure equality of rights and responsibilities of spouses as to marriage during its subsistence as well as its dissolution. Full stop. Learned counsel for the petitioner contends that the action of the respondent is violative of the rights petitioner under the international covenants as well. Full stop. Stanza. On the other hand, learned counsel appearing for the respondent has vehemently contended that on the date of her marriage, the petitioner was aware that her application for resignation stood rejected and that she got married despite this fact. Full stop. It is contended that therefore there was no unforeseen circumstances which would now entitle the petitioner to resign her commission. Full stop. Reliance has been placed on pronouncement dated 14th December 2004 passed in WP number 436/2004 to contend that the petitioner has no absolute right to grant of an application for resignation. Full stop. It has been vehemently urged that this court has limited powers of judicial review so as a challenge to the action of the respondent based on policy is concerned. Full stop. The submission is that the petitioner has also undergone extensive training and has acquired her expertise in the field only on account of the training imparted to her by the respondents, which is followed by her experience on account of her employment with the respondent in the nursing service. Full stop. It is argued that it cannot be ruled out that the petitioner was seeking to quit service on account of better civilian prospects. Full stop. Stanza. It is also urged that there is deficiency so far as availability of personnel in the service is concerned. Full stop. The submission is that public interest demands rejection of the request for resignation. Full stop. Learned counsel has further contended that the petitioner never approached the respondents placing her marriage or any marital difficulties in support of an application for resignation. Full stop. The respondents also challenge the jurisdiction of this court to grant such a prayer In the present proceedings, full stop, the petitioner was not married when she made the earlier application which resulted in the impugned order dated 10th November 2007, full stop.